Hello guys, I'm Kartikeya. I'm the team of LEXIS and Company. So let's go directly towards our discussion which we held in our previous video. Now we discuss about public trust doctrine in Indian perspective according to Indian laws, and how it play an important role in Indian constitutions, and what are the leading case which helps the development of this doctrine. So let's first discuss about the Indian constitutions, which provide some of the articles which can be influenced and which can be interpreted with reference to the public trust doctrine. First is the Article 21, which was one of the most important article in our constitution, which provide and guaranteed for a right to life of every citizen in India and every person in India. According to Article 21 is the right to life, and in various interpretation and various judgment by the Supreme Court or Honorable Supreme Court, which given that the Article 21 can be interpreted in such a way that it can be says that a person have a right to life with an environmental free and pollution free environment, which says that directly says that the environment which having a pollution which can lead to directly affect the health of a person, and which can leads which violates its fundamental right to life. So the court interpreted that a person have a right to life with a right of environment pollution free environment also. So in this case the doctrine fostered that a pollution free environment which is a part of right to life. Thus the doctrine also having a great influence in this article. As in another article which we discuss about is Article 39B, is an DPSP, which says direct the state to made a policy towards an state to made an ownership or control any material resources for a communities so as to distribute it as the best to serve the common goods, which can be says that that the state have a duty to conserve all its natural resources, to distribute such resources in a better way, in a scenario that all in a particular individual does not, a private party does not get all the resources, it benefit public at large. So in this case we can say that the state having act as a trustee to conserve such natural resources. Another article is Article 48A, which says that the state shall have a duty to protect and improve the environment and to safeguard the forest and wildlife of the country. So in this article we can also say the state having a duty towards the conservation of natural resources and wildlife of our country. So we say that the constitution has not any specific specially provide that the state the owner of natural resources of environment or forest, but the state has in a position to act as a trustee who is required to protect and improve the resources for the public at large benefits. So in this case we can interpret all these articles in reference to the public trust doctrine. Now we discuss about some of the landmark judgment. So first we move on the first case which talked and court highly rely on this doctrine is the MC Mehta versus Kamalnath in 1997. In this case we can say that the court observed that the public trust doctrine play an important role for the interest of mankind and in the interest of the nations. So court quoted these two sentences in this, and thus it makes that the public trust doctrine is a part of the law of the land. So in this case the court highly rely on the public trust doctrine for the benefit of all the natural resources which are present in our country to be distributed or to be conserved in such a way that it benefit public at large, not to be used any by private party or any for a commercial purpose. So in this way the doctrine plays an important role in this case, as we know that the MC Mehta is one of the renowned petitioner to protect and conserve our environment. So these doctrine has played an important role to find out the default or dismiss the argument stated by the government for the construction of near the conservation. part. So in this case we can discuss about what are the landmark landmark points stated by the honorable Supreme Court towards the public trust doctrine plays an important role in environment protection and how it helps the public at large to benefit from the natural resources. Now we move on to the further another case which having an important observation and Supreme Court order is the MI Builder versus Radheshyam Sahu, AIN 1999. So in this case also court highlighted that the policy or the regulation construction tender proposed by the municipal corporation of city of Lucknow, which proposed an underground shopping complex in a forested or garden which affects the environment or ecosystem of that area. And so court held that the municipal had violated the public trust doctrine because they are the duty to act as a trustee, not as an owner of such a piece of land resources. So in this court ordered that the demolition or authorizing the shopping complex which was already constructed on that ecosystem which is sensitive to any invention or any affect by the such invaded by the humankind. So in this case also the public trust doctrine play an important role. Now we concluded and how we says that the public trust doctrine is highly useful tool in handling our judiciary to protect and preserve the environment from the arbitrary or unreasonable action of the government authorities. Thus we can say that the public trust doctrine would work as an effective tool to check of the exercise of power by the government with regards to dealing the management of natural resources. So I think that the public trust doctrine plays an important role and we have to understand how it play an important role to conserve our and protect our natural resources. So I hope you guys like this video and I wish you all in a to stay safe and in good health. Thank you guys.